Good evening. I really wasn't planning on making a video tonight, but I elected to because something came across my desk that I took note of, and I wanted to pass it on. Before I get that, this is not legal advice. Please like, subscribe. Please do so. Share it with your dogs and other animals that you choose. Some bad news on my part. I got fired at my job as being a set designer, but the good news is I left without a scene. Anyway, moving on. This is directed at the Gtii Alpine Finra matter, and just to bring everybody up to speed, Finra was trying to move forward with an expedited proceeding to expel Alpine so that they couldn't do any more business, if they are doing business, but to completely basically shut them down. That was done because they had committed numerous violations of a prior order that directed that they cease and desist that kind of conduct. So they apparently committed a bunch of violations, and I talked about this, and I also was a little not very happy that Finra didn't take action sooner, because the original order saying that Alpine couldn't do any more bad stuff was April of 2022. Finra didn't really take any action for a year, 35,000 violations. So I was kind of pissed about that. Did some videos about that. Anyway, so there was a bunch of legal proceedings, and eventually Alpine got an injunction. Excuse me. Alpine got an injunction stopping Finra from being able to go forward. That was during an appeal, and it was the appellate panel that issued the injunction. So recently what happened was Finra then went back to the appellate court, the entire appellate court, since the first decision granting Alpine the injunction was before a 3-judge panel. And that 3-judge panel, at least 2, were sympathetic to the arguments that Alpine was making, but that's not the entirety of that particular court. So Finra, who lost at that particular hearing and now would have to wait to go through an appeal, is trying to get the whole court to overturn that ruling of that limited part of the appellate court. And so they filed a motion. And today, and that's why I'm making this video, Alpine filed a response to Finra's motion. And I reviewed it, at least in parts, a 17-page document. And basically, to summarize the arguments made by Alpine, one, and it's, so the request that's outstanding by Finra is to have the whole appellate court hear this particular issue. So that's what the issue is. So the first argument that Alpine makes is there's no reason for the whole court to hear this issue, and they cite some cases, etc. And basically the position is, if it doesn't involve a dispositive motion, dispositive would be some motion that could decide the entire case, then there would be no reason for the entire court to hear the matter. And the prior matter that we're talking about was an injunction, which wouldn't be a dispositive motion. So they're saying because of that, the entire court shouldn't rule. So that's the first kind of procedural. Second, they're basically saying that as set up, because of the setup of the SEC and Congress, that in effect Alpine, at least as to the enforcement of securities law, is a state actor. And as such, they're subject to specific constitutional provisions, one being like due process, obviously. So if they're a state actor, in other words, if they are treated like they are the government, then they also have to comply with the Constitution as to people they deal with. And So the provisions would be one, due process, which would be per the Fifth Amendment of the Constitution. So, for example, hearings before, let's see, the SEC and Finra may not be exactly the same as if you went to a district court. So the district court might provide you more process. So if you are subject to being a state actor, then you might also be subject to being in federal court, which would give you more rights. So that could be an issue. The other point that they raise, that's one. But there's other provisions of the Constitution that are at issue and that are going up to the U.S. Supreme Court, and they include the issue of the Appointments Clause. So there's a provision that says if it's basically an executive function, that the president should be firing and hiring. And in this case, there's a lot of layers between the executive branch and these operators, and as such, it's a violation of the Constitution, the Appointments Clause. It's also, and I'm no constitutional scholar, by the way, and also it's a violation of the separation of powers and inappropriate. And there's other cases that are going to the U.S. Supreme Court, at least one, that is also going to be directed at that issue. So that's one issue. The other issue is that if they're not a state actor and not subject to the Constitution and the provisions of the Constitution, then what they've been delegated by FINRA, or in essence Congress, is a non-delegable function. So in essence, it's a function that only Congress can carry out, and they can't delegate it to a private entity, which would be, if they're not a state actor, then they'd be a private entity. And that's the other argument. And again, this particular court, at least to this point in time, has been sensitive to those arguments. So looking at the brief, there was no oral argument currently scheduled, but now we've had two briefs. There's an additional briefing schedule on the appeal, and I know it's complicated. So there's an appeal, but what we're talking about now is an injunction. So theoretically, you could lose the injunction and the appeal could still go forward. Kind of two separate proceedings within one. So they're looking, now it appears they're trying to come to a conclusion on this injunction issue. And in effect, if the court says that we're not going to hear it, then the appeal will have to go forward. Now, again, as I've professed in the past, that shouldn't stop FINRA from going into federal court based upon all the violations and seek an order to either get the appointment of a receiver or something equivalent to a receiver to take over and shut the business down, especially if they're still committing violations. And it's interesting also in the argument here is Alpine is contesting that they did anything wrong, because in effect they're contesting the prosecutorial and enforcement wings of FINRA and the SEC, and they're just saying just because they found us responsible in the past doesn't mean we were, and they're giving no validity to those charges. I found that kind of interesting. I don't think it'd go very far, but the other constitutional issues may. And if they are, it also, again, might impact FINRA's ability to mandate and govern arbitrations, mandatory arbitrations that retail has to be forced to go through. And I'm in one, so it's relevant. But it may be much broader to impact the way future arbitrations are undertaken or if they're required. But the bottom line is, just kind of to sum up, so there's another brief that was filed. There may be additional briefs. This is as to whether the entire appellate court should consider the injunction that was granted by the 3-judge panel. They will either say, yes, we shall consider it. If they consider it, they could say yes or no, we agree. However, if they elect to consider it, it may be because they may have a different view, or maybe they have almost a unanimous view. Really don't know. Or else they could rule not to engage. And if they don't engage, then the existing ruling stays forward, and the proceedings would go forward as an appeal, and that would be sometime towards the end of 2023. In the meantime, Finra could still go into federal court and take action against Alpine based upon the violations with evidence and a new case. So that's kind of where it sits. In the meantime, there's no reason for Finra not to go into federal court and try to get a receiver or trustee appointed. So that's the sum and substance. And as any new briefs come in, I will let you know as they come in. Take care. Have a great night. Be well.